好，各位委員，早晨。
Good morning, members. We have already formed a quorum, so we can call the meeting to order. Secretariat staff, please invite the deputations and officials attending today's meeting to join us first. In attendance from the administration, we have Mr. Lau Kong-wah, Under-Secretary for Constitutional and Mainland Affairs, Mr. Zheng Doi-ching, Principal Assistant Secretary for Constitutional and Mainland Affairs. From the Department of Justice, we have Ms. Daphne Siu, Assistant Law Officer, Mr. Godfrey Ken, also from the DOJ, and Mr. Manuel Ng. And from the Bureau, we've also got Mr. Michael Yao. Next, I would like to extend a welcome to the deputations and individuals in attendance. Today, altogether, there are 17 who have registered to address the Girls Committee. A list of the names can be found in the paper tabled for your reference, members. A number of organizations have given us written submissions, but they are not going to come in person. They include Mr. Yang Wai-sheng, member of Eastern District Council, the Law Society of Hong Kong, the Chinese General Chamber of Commerce, and the Hong Kong Catering Industry Association. Their submissions have been copied to the administration and members. For the deputations and individuals who are attending today's meeting, just a word of reminder, if necessary, you may want to put on the earphones, and channel 0 is the floor, mainly in Cantonese today, I expect. Channel 1, Cantonese, channel 2, English, channel 3, 普通话. In a moment, I will give the floor to the speakers in accordance with the sequence indicated in the list before you. Each of you will be given no more than 3 minutes. When the buzzer is sounded, then it means your time is up, and on either side of the conference room, you see the timer. Once you have spoken, if you're willing, you may give a copy of your statement to the Secretariat. Just want to remind deputations individuals that when you give your submission to us, you are not entitled to the protection and exemption under Electoral Powers and Privileges Ordinance. In your information kit, you have got a copy of points to note for members of the public who are in attendance. Please take a look of it. All right, I think I'll give the floor to the deputations. First of all, from Amnesty International Hong Kong, Ms. Choi Kowloon. Thank you, Madam Chair. For Amnesty International Hong Kong, we are in support of the amendment bill, an amendment to the Sex Discrimination Ordinance, but then it is too late to do it. In the year 1999, the Equal Opportunities Commission, during the review exercise of the discrimination laws, in the report, there was already a suggestion to provide against sexual harassment of a service provided by a customer. It is only in this year, in 2014, that the administration is proposing a bill. So you can see that there has been a delay of as much as 15 years. We hope the administration will explain why. Though it has said that it would not object to it in principle, it will take them that long to come up with the bill. I hope that the same won't be repeated again. In this year, in relation to the discrimination laws, there is a public consultation exercise. For question 39, it is said that we should give views on sex harassment offences. In fact, all of them have been mentioned in the 1999 report. Say, for example, prospective members, tenants being harassed by other tenants. And in fact, in the year 2000 report, the administration has said that there would not be any objection in principle. Want to know why the other elements have not been included in this bill so as to amend the provisions. In the consultation exercise, the proposals are still inadequate. In the case of Moisi against Yun Sa, the court has suggested that there should be an offense against sexual harassment among students, but then this hasn't been taken up by the EOC. And then for club members and prospective club members, for them to be protected against sexual harassment by other club members, I think it should also be an offense, and I hope that the administration and the EOC would follow them up and provide improvements. Thank you. Thank you. Next, from a concerned group saying that the manpower ratio is against minimum wage, Mr. Wong Kwai Seng. Thank you. Well, I've just finished with my contract with the Jockey Club. I don't know whether it is a case of discrimination. The contract hasn't been renewed. I used to work with the Jockey Club. Well, in fact, last year, clients criticized us in the paper, saying that no one was receiving their telephone calls. We are really put in a very embarrassing situation. We were contract staff. We couldn't leave while other staff members were asked to leave. Now, whenever a client succeeded in getting through the call, they would start to hurl verbal abuses against us. Are we paid to be scolded? I think this policy is most terrible. In the year 2004, we used to get a gratuity upon expiry of the contract, 6% for the contract staff. Someone used abusive language against me, and then my supervisor took me into the office, and I was told that a client complained against me. Well, others didn't turn up to work. I had to bear the brunt, and clients were using abusive language against me. Why should that be so? Well, in fact, last year it was even worse. Now, many clients were airing criticisms against the race commenters as well as the staff of the call centers. Well, part-time staff can end their duties anytime, but we as contract staff can't, and we have to stay on to be abused by others. When we fall ill, well, in fact, for us contract staff, we don't get any medical benefits. Well, they have just stopped they've just refused to renew my contract, probably saying that my attendance rate is not good enough. Well, I saw that many others left, and then during the small hours, we just have a handful of staff members. And unfortunately, I have to tell you, Madam Chair, an office bearer of our trade union suffered from exhaustion from the heavy workload, and he passed away owing to cancer.
All right. He's not entitled to any medical benefit, and well, they also mount an operation to try and catch people who submitted false sick leave certificates, and there are only about 100 or so staff, staying behind. So I really hope that you can amend the legislation so that there will be no further such a harassment. Next, Hong Kong Women Workers Association, Ms. Leung Wai Ching. Thank you, Madam Chair. With regard to the proposed amendments to the Sex Discrimination Amendment Ordinance, it's been 20 years before this proposed amendment, and it's to ensure that providers would not be subject to customers' sexual harassment. We support that, but then it's a bit too late, and also the scope of the amendment is too narrow. We have come into contact with some cases whereby the victims are actually the outsourced cleansing worker, but then while they are at work, a security guard abused them, but then as they are not employed by the same employer, in other words, their employers are different, and in the end, the EOC replied that her case could not be dealt with. And I think there are many such examples, and there are many victims who are not protected. We believe that the EOC should introduce provisions involving third-party harassment. So, in other words, the employer has the duty to protect their employees if there is third-party harassment, and if he is not able to do so, then he will have to be legally liable. So I'd like to stress that the SDO can expand the scope of protection so that the provisions will be able to protect more people. Second, even if the amendment is made, the EOC will also have to take up its duty as an active supervisor or observer. There should be stepped up education so that the employers will provide a safe workplace for their employees, and the complaint mechanism would also have to be beefed up so that proactive action can be taken to avoid sex harassment, because employers do have an active role to play by providing a sex-friendly environment. As the existing legislation is not able to protect many women, and as a result they have not been able to file complaints, and the EOC itself has not got a good complaint mechanism in place because it's not very friendly, and therefore many victims have nowhere to turn to. It only accepts written complaints, and we have also tried to help the victims by setting out their grievances in writing, but then very often we will have to have 5 or 6 rounds of correspondence, and as a result the victims would be very disturbed and annoyed. And also there is a sex orientation perspective, and as a result that would mean double jeopardy to the victims. On one occasion we tried to write to the EOC to ask for the details of progress, but then the EOC said that how come after the first instance the harasser was still able to come into contact with the victim. So apparently the burden was placed on the victim, and this is most irresponsible. And we believe that in the process of dealing with the complaints, the staff of the EOC should also be trained so that the victims will be able to file effective complaints against the harasser. All right, the fourth deputation is not here. So next, Hong Kong Jockey Club Workers General Union, Ms. Wu Shaolan. Good morning, Madam Chair. We are also from the Jockey Club. We have come into contact with customers who come to place bets, and honestly, well, they are gamblers, and they would often be very unhappy or upset if they lose, and they would hurl, swear, or abusive language against us. And we have also filed complaints with our employer, but then as you have not introduced the amendment, that's why our employer often told us that only the customers had the right to file complaints against us, not the other way around. So I'd like to know that, well, the EOC is dealing with cases of abuse if we hurl abusive language against our customers, but then when the customers just scold us without any reasons, then why can't we complain against them? So it's just one direction, so it's not equal opportunities at all. We hope that something can be done about it so that the EOC will attach importance to such issues so that we will all enjoy equal opportunities. Thank you. The next deputation has not arrived, so the one after it is the Women's Affairs Committee from the Hong Kong Confederation of Trade Unions, Ms. Yu Mei Wen. Good morning, everyone. With regard to the SDO, we believe that the provisions should be expanded so that more areas can be covered, so as to proactively prevent any possibility of sex harassment, so that for employers, they would try to protect their employees from being sexually harassed, and the code of practice should also be beefed up, and we believe that should be supported. With regard to the proposed amendments, both the government and public bodies have the responsibility in promoting equal opportunities. I think that would also set a very good example in reducing harassment cases, and that would also reduce litigation costs and social costs. In fact, the EOC has the responsibility of coming up with a good complaint mechanism so that for victims they would be better protected. I can give you a concrete example. Well, I am working as a night shift security guard, and for security guards, most of them are males. And very often in a control room, when they have spare time, they would read newspapers, and in particular, the pornographic section, and they would try to quickly go through it, and then they would laugh and joke about this. And when other colleagues arrive, they would also talk about what they do during their spare time, and they never think about the female colleagues who are just seated next to them, and they would feel very embarrassed. And I once filed a complaint with my supervisors, and he said, what's the problem with that? They are treating you as one of their peers, and they are treating you as if you were a male colleague. And when I tried to go one level up further, and he said that, all right, I'll just talk to them. So that precisely shows that in many companies, there is a lack of safeguards or protection for their staff, and there is also a lack of awareness amongst staff members of these companies. In other words, education has not been done properly. It's not just about the scope of sex discrimination that should be changed or broadened. In fact, for years we have been fighting for legislation on age discrimination, so that people would not be discriminated on grounds of age, because according to our contacts, for people of different age groups, they have not been able to enjoy equal opportunities, and many employers would discriminate against people who are older, whether they are just job applicants or existing staff. Taking the airline industry or aviation as an example, in many airlines they would also require that air hostesses would have to retire after they have reached a certain age, and for the air hostesses stationed in Hong Kong, they have also filed complaints, and they have not been afforded legal protection. In the end, they had to seek damages from a UK court before they can get justice. So it shows that there has been a lack of protection on grounds of age discrimination, and the administration should introduce law as soon as possible on age discrimination in order to protect people of different ages, so that they would not be subject to discrimination. Thank you. Thank you, Ms. Yu. Next, Hong Kong Women's Coalition on Equal Opportunities, Ms. Wong Siu Moon. Thank you. We represent 12 non-government women organizations, and we welcome the proposed amendment to the SDO. And as some deputations just said, in fact, it's too late. And this amendment is just a very minor and patchy amendment. And in fact, during early last year, the Women's Coalition conducted a survey, and we interviewed many women in Hong Kong society with regard to their experience with regard to physical violence. And many women workers have been subjected to sexual harassment, and the situation was very serious. And indeed, over 80% of those working in the catering industry were once subjected to sexual harassment. They were touched on the body, or they were subjected to abusive language with sexual inclination and so on. And And basically, there is an unequal footing between the employees and the employer. And because when employees are in a disadvantaged position, they often would have to put up with such abuses. And therefore, if we do not amend the legislation, we will not be protect these frontline workers, and they can only put up with further abuses. And they would also not get support from their employers. In fact, earlier on, we also conducted a questionnaire in the business sector about sexual harassment, and in the business sector, the response was very lukewarm. In fact, many companies, in terms of prevention of sexual harassment, does have this responsibility, because the company concerned has to ensure that the workplace is a safe environment for its employees. And therefore, other than legislation, the AOC would also have to step up its role as a monitor or regulator, and whether or not it's SMEs or large companies, they would also have to come up with a complaint mechanism and a sex discrimination policy in order to prevent sexual harassment. As we welcome this amendment, as there are many people who are subjected to sexual harassment and their situation has been ignored. For example, with regard to government employees who abuse members of the public, that has not been covered. And also for sexual harassment on campus, there is also no liability on them, and therefore there is no such policy to help them. So we welcome this amendment by the administration. We also have to take reference from the EOC's recommendation in the past to introduce relevant legislation. And after the legislation is enacted, corresponding code of practice would also have to be introduced by the EOC, so that companies will have to undertake to implement the or enforce the amendment. And we believe that the complaint mechanism of the EOC would need to be improved. Thank you. Next, the Hong Kong Federation of Trade Unions Women's Affairs Committee, Ms. Law, of the Federation of Hong Kong and Kowloon Labour Unions, Ms. Law. Yes, the current legislation is not able to protect frontline female workers. In fact, the service sector is one of the main pillar industries in Hong Kong, and therefore, when compared to other sectors, they have more chances to come into contact with customers. But then under the existing SDO, it only says that for employees or service providers abusing customers, they would be punished. But then on the contrary, there is no corresponding legislation regulating or governing customers abusing service providers. And also, if that's allowed to continue, that would definitely affect Hong Kong as a civilized city. And also, the amendment should be implemented as soon as possible. There should be no further delay. As a labor union, we often receive complaints from workers and employees, in particular salespersons and also air hostesses or flight attendants. They have been subjected to a lot of harassment. Very often it would be verbal and physical abuse, and that would also give rise to a lot of disturbance to them. That's why, with regard to this amendment, we welcome that, and we also hope that this amendment can be approved as soon as possible, and that should also be implemented. Certainly, the legislation must come with stringent enforcement, because the purpose is to improve the rights and interests of those working at the front line. But then the employer would also have to ensure that the employees would not be subjected to sexual harassment at the workplace, and therefore it should also spell out that the company and also the employer should also set up an effective complaint mechanism, so that for victims of sexual harassment, they'll be able to take their case through the complaint mechanism. Because many staff working in the service sector, they have nowhere to turn to, and their employers would also ask them to put up with such harassment without filing complaints. And therefore, we encourage that the amendment be implemented as soon as possible. Thank you.
Next, Ms. Tang Yulihua, Deputy Director of the Hong Kong Federation of Trade Unions Women Affairs Committee. Thank you, Madam Chair. The Hong Kong Federation of Trade Unions Women Affairs Committee has always been concerned about women interests. In 1995, the SGO was enacted. It provided against discrimination on the ground of pregnancy, sex, family responsibility, etc. But then the protection against sexual harassment is inadequate. As early as 1999, the EOC suggested that we should amend Section 40(1) of the ordinance, but then a proposal has never been taken up, so that service providers will be protected against sexual harassment by customers. Now, we want to protect the interests of the workers, and we have zero tolerance for such sexual harassment. Between December 2013 and February 2014, together with the EOC, we carried out a survey concerning sexual harassment at workplaces. 20% of the respondents told us that they have been sexually harassed. Usually, they got it from their co-workers as well as from the clients. According to the complaints received by the EOC, at workplaces, there has been more cases of sexual harassment. Unfortunately, the legislation is outdated, and for clients sexually harassing the service providers, this isn't an offense yet. Therefore, the bill's proposal to amend Cap 480, the FTU Women Affairs Committee supports it. And according to our survey, we know that most companies do not have a policy statement against sexual harassment of this nature. We have to amend the law, and we must also have good monitoring work so as to make sure that employers will have the policies in place and the procedures to deal with the complaints, so as to make sure that there won't be any harassment and bullying at workplaces. 90% of the respondents told us that they have never received any anti-sexual harassment training. We are a trade union, we're a federation of trade unions. We should publicize the rights of the workers so that they will be free from sexual harassment. In this year, we organized a workshop, and we allowed participants to learn how to enhance their awareness and prevent themselves from falling victim to sexual harassment. And therefore, our committee, as far as this bill is concerned, would like to say that we have to enhance the protection for the service providers against sexual harassment. Thank you. Next, Mr. Dominic Lee from the Liberal Party Youth Committee. Thank you, Madam Chair. The administration would like to amend the SDO. We welcome the proposals in the bill. We have noted that it is unreasonable to have an offense against service provider sexually harassing customers, but not the other way round. Well, in fact, many people have been surprised to learn about such a gap. So we welcome the administration's proposal to amend the bill, to amend the ordinance. In fact, for workforce, we have got many women working at the front line, and day in, day out, they are vulnerable. And in fact, we feel for them. And we have heard the other speakers that employers should in fact be made liable for this offense, but we have worries and we have reservation. This is because in the catering industry and in the case of the flight attendants, well, in fact, every day they come across a large number of clients. I just wonder if the employers have the ability or the system to prevent their frontline staff from being harassed by their clients. I just wonder whether they should always be made liable. Well, I think the offender should receive a heavier penalty, and only the offender should be made liable. Just now, a women's group has said that we need to improve the complaint mechanism of the EOC. I think if that is done, then it means that frontline officers will get a platform, will get the opportunity to lodge a complaint with a government authority against a harassing customer. Well, in fact, even male workers are vulnerable to such problems. In this way, both sexes will be protected. Next, Mr. Dan Chen from the Alliance in the Catering Industry Against Sex Discrimination. We welcome the proposal to amend the ordinance to make sure that we afford greater protection to our staff. But then I don't think employers should be made liable for the acts of their clients. It is not easy to run a business. It's not easy to manage your own staff, not to mention that you expect the employer to monitor and manage the behavior of their clients. And then for the bosses of the catering industry, maybe they don't have a lot of education and they may just have started as a junior chef. I can imagine that the easiest way out is that you better avoid employing good-looking staff members. Then you run less risk. No employers want their employees to be harassed. It means that recruitment will be even more difficult, quite unlike the Jockey Club. Sorry. I would like to ask our colleagues to show respect to members who are speaking. So I'll give you back 30 seconds. I think SME is quite unlike the Jockey Club, won't be able to introduce the relevant measures. That would only make it even more difficult for SMEs to run their business. Thank you. You haven't used up all your time. Next, concerned group concerning the SDO, Mr. Harris Young. Thank you, Madam Chair. Sexual harassment is, of course, an offense. We should deal a great blow against it. On the other hand, it is very odd to find that customers harassing the service providers, well, probably the boss would not want to offend the customers, and yet, of course, they found that it is not something that is to be welcome. You can expect bosses not to welcome such problems. So we have to deal with the problem instead of just shifting the burden on the employers. As it has been pointed out by some deputations, I think it's a matter with the complaint mechanism. Otherwise, it's like disputes or fights among fellow students, and yet you make the teacher vulnerable. Is it fair? Now, for a boss to see that there is a case of sexual harassment between this staff member and the customer, I think the employer would find it very difficult to deal with it. It's better for the government to come in, and then it is a matter of protecting the interests of the employee as well as the employer. I think the government should take up the responsibility. I don't think you should make the employer liable, thinking that it is to the in the best interest of the employee. Well, in fact, on the question of sexual harassment, we should define the role of the government and the degree of cracking down on it. I don't tolerate sexual harassment at all, and that's why I would like to use the term cracking down. And I think the government is still bound to take up this role. Thank you. Next, ban gay marriage Hong Kong, Mr. Peter Shiu. Thank you, Madam Chair. Well, for the proposal in the bill to assist the female staff, especially those in the service industries, against sexual harassment, I think everybody would be in support, including myself. Now, I've come under the banner of Ban Gay Marriage Hong Kong. You may wonder why. I have heard that even male employees will be arrested. And so it is suggested that we should adopt a more neutral term instead of using he or she in the provision. Well, in fact, I have been a victim of sexual harassment by males and females. So I think we should cover the male victims as well. But I don't want to use a neutral term. You're either born a male or a female. Now, a male person may undergo surgery and become a female. Then the sex will be very clear-cut. Now, it is already very chaotic outside this building in the Admiralty. So I don't think the government should do the same here when it comes to amendment bills. And then, secondly, I want to address a point made by other members, that is the role to be played by the employer. In Hong Kong, many people are very righteous and they want to do justice. In Causeway Bay, if you indecently assaulted a young girl, I'm sure you can't get off, and before the police arrive, passers-by would have already caught you. Now, if you see a criminal act, if you don't help, is it also against the law? Well, I think if you start to do this in this context, then probably it will be extended to other realms. Now, if somebody sexually harassed, then the victim can report the matter to police, or you can pull in more government departments to help. Now, if you start to drag in the employer, how are we going to define who is the employer? The employer may not witness it. Is there a role for him to play when he goes to the court? What sort of role will be expected of him? So if you start to ask the employer to become liable, well, in fact, the government departments have many customer service. Does it mean that CY Leung would be kept very busy and have to attend the court every day? Two other groups haven't come. And then I would like to give the floor to Ms. Mack, organizer of the Association for Advancement of Feminism, third on the list. In relation to the bill, so as to extend the protection under SDO to cover also sexual harassment of service providers by customers, and to cover the scenarios in which acts on an aircraft or ship registered in Hong Kong will also be included. We welcome this. But then what about the educational sector? Here, the bill only covers things in the employment realm. But in fact, it has been considered by the UC that perhaps we should also try to look at the case of the vicarious liability. I think schools should also have a policy. What about in a hospital setting, among patients and between patients and the staff, and what about other residential homes? I think there is no protection against sexual harassment among the patients or the residents. And what about tenants? Among tenants, well, many people are living in subdivided units. You have to share the kitchen, you have to share the toilet. Among tenants, again, there may be the risk of sexual harassment among the tenants. In 1999, I think the question of management of premises has been covered. And what about civil servants? According to Section 21 of the SDO, but then when a civil servant is enforcing the law, and if he sexually harasses a citizen, it is not yet an offense, just like the case of police officer and enforcing the law. And then for security guards, I think a security guard may cite the excuse that he's not providing service or goods, and he may be let off. And then under the SDO, for sexual harassment among students, it is being protected.
But then there is no such protection afforded to students from different institutions, and there are many joint university or institution activities, and very often alumni will also go back to their alma mater to help out in activities. But then they would not be protected if they are sexually abused. For example, in 1999, in a high court case concerning sexual harassment, the judge already dealt with cases involving students from different institutions who were being abused. And also, we also have to introduce a code of practice on education, on sexual harassment, and also race discrimination. Thank you. Thank you, deputations, for your remarks. So that's the end of the deputations submissions. For those who have not turned up today, they can either write in or give us further views in writing. There are some members who have raised their hands and they'd like to speak. So I'd like to ask if the administration would like to wait till after all the members have spoken before you respond, or would you like to make an initial response first? All right, the floor is now open to members. First, 3 minutes first, Raymond Chen. Thank you, Madam Chair. I have two questions. One is about neutrality. Well, last time we also, both Sit-Ho and I raised this point. That is, under the law, female would also include male. How about transgender? And, well, the administration's response was rather wishy-washy, and under the IGP's in the general clauses and interpretation ordinance, the interpretation was that was amended in 1993, and according to my understanding of that clause, well, under the law, if it's written female, then that would also include transgender or neutral sex, and there is no specific requirement for the specific gender to be stated there. So can the administration confirm if that's the case? Because last time the answer given by the administration was rather wishy-washy and vague. Mr. Lau, indeed, Mr. Chen and Ms. Sit-Ho did raise this point, and we also attempted to answer. At present, in dealing with the issue of neutral sex, they would also accept such complaints. That is under the current law as it is provided. If there are complaints, whether or not it's raised by a male, a female, or a neutral sex, the complaint will still be dealt with, and whether or not that should be spelled out expressly in the law, as we still use male or female as the basis as to whether or not there will be changes in the future and how it should be amended. Well, as we can see, within the EOC in its consultation document is already consulting the public on this. That's why, as to what changes are necessary and how changes should be made, I think we have to wait until after the consultation exercise, and then the EOC would submit its recommendation to the administration, and then we'll consider it. Well, with regard to the general interpretation clauses ordinance, section 7, can that interpretation be applied to this? Can the DFJ supplement on this? Thank you, Honourable Member. With regard to interpretation and general clauses ordinance, section 7, with regard to the application of this ordinance under section 2 of the interpretation and general clauses ordinance, it says that unless otherwise provided in this ordinance or other ordinances where definition of the contrary, if set out, this law will apply. Now, coming back to section 7 of the interpretation and general clauses ordinance, the point is about the law drafting division. In recent years, we try to adopt an approach which does not carry any sexual nuance. But then before we introduce this policy, in terms of drafting the law, we have followed the UK's convention. And the approach is that we will use a specific gender in the writing. For example, when we are referring to a human without specifying the gender, then we will continue to use he or his with a specific sexual nuance. That's why whenever the term he is used, actually she would also be covered. But then it would not say that for any term referring to female, it would also be referring to male or either. So Section 7, if it's read together with Section 2 of the ordinance, then it will not be applicable to all circumstances, i.e., if there is meaning to the contrary, then it will no longer apply. And if you look at the SDO, Section 40, it specifically refers to female, and also under Section 2, bracket 8, it says that female also means male. In other words, the purpose is about the specific person involved. So it would also exclude the application of Section 7 of the Interpretation and General Clauses Ordinance, the IGCO, or else there is no way that we can specify a particular gender. With regard to Section 7, if the person is neither a male or female, in around 1993, when the IGCO was amended, this particular clause was added, and in the explanatory note, it's also specified that with regard to this amendment, it specifically targets the so-called legal person. By that we mean certain companies and legal entities. They would also be treated as if they were persons, and therefore for male that would also refer to female. So even if we have not specified the specific gender, but then as soon as we use the word he, it would not exclude a female. And there are also legal persons who are neither a male or female, and therefore we would use the word it. That's why when we talk about the person who's neither a he or she or male or female, we are referring to legal persons, i.e. entities. Dr. Helena Wong. I'd like the administration to clarify this for us. Well, there was a women's group with regard to harassment by civil servants towards women, including policemen. So can the DFJ give us an answer? With regard to policemen, or within the police force, would they also be subjected to the SDO? Because as we know, in mass or public rallies, there have been complaints against policemen, and at the IPCC, I have dealt with, or I am in the process of dealing with cases involving protesters who were being bear-hugged by policemen, and we are actually in the process of writing up a report that would be released shortly. So when a policeman is involved in an operation, and if he harasses a female, then would he be subjected to the SDO? DFJ, thank you. Concerning the case of government employees, well, actually under Section 21 and 38 of the SDO, there are clear provisions or express provisions. Generally speaking, in the course of discharging the government's duties or exercising its powers, if there is suspected cases of sexual discrimination against women, then the government would be deemed to have violated the law, and therefore, if government employees, in exercising their powers and discharging their duties, if they have committed any acts which are in contravention of the SDO, if they have committed acts which are covered by the SDO, then they would also be subject to the regulation by the SDO. And I'd also like to take the opportunity to explain that some deputations have said that government employees, if they sexually harass their service targets, then there is no protection whatsoever. In fact, under the SDO, it provides that the ordinance is binding on the government. In other words, if government employees are found to have committed the acts covered by the SDO, then they would also be violating the law. And as I just referred to, Section 21 and 38 of the SDO, they refer to circumstances of sexual harassment. Sorry, it's about sex discrimination against women. So it's about sex discrimination against women. With regard to sex harassment, as I just said, for government employees, if they are involved in sexual harassment, then that would also be against the law. In other words, the SDO already bans government employees from sexually harassing the targets of their services in the course of their work. In other words, members of the public would be protected. Yes, Ms. Wong. Madam Chair, he refers to Section 21 and 38. They provide that members or employees of the government cannot abuse or sexually harass women, or else they would be breaking the law. Is that the case? Well, I'll give you another round to speak. Ms. Sito and then Kwok Wai Keung. Madam Chair, I'd like to follow up on Ms. Mack's point, the Association for the Advancement of Feminism. I'd like to ask further follow-up questions. When policemen enforce the law on sex workers, if they commit acts that are against the law, including indecently assaulting them, and in some cases they would also be snatching their money. So we have heard those from time to time. So these are actually even more serious acts when compared to sexual harassment, and in many cases we have not been able to follow up on that. So I'd like to know from Ms. Mack, according to what you know and also the cases that you have received. So have you been successful in filing complaints against the policemen concerned, or is it that in many cases the victims dare not or have not come forward to file complaints? Is that prevalent? And also in the government's reply to our questions, they also gave us some figures about follow-up figures by the EOC, and from 09 to now there were about 512 such cases. Only 16 managed to get legal assistance and managed to go to the court. So I'd like to know, according to your figures, with regard to the approach adopted by the EOC, there were so few cases that managed to go to court. So in terms of the collection of information and how the employers are facing the inquiries or investigation by the EOC, how come there were so few cases that were heard in the court? And in fact, all the cases managed to get conviction. So they were successful cases, but then how come there were so few cases? So can I ask Ms. Mack from the Association for the Advancement of Feminism to respond? Sorry, I don't have the figures with me, and therefore I'm not able to give you a definitive answer.
Just now, the member talked about police officers taking action against the sex workers. they are not able to lodge any complaints. They know that even if they do lodge a complaint, nothing would come out of it. Now, even for the general public, it will be difficult to establish a case, not to mention that it is a case involving a sex worker, as they have been stigmatized by the community. So if the EOC can do something about it to mend the gap by proposing an amendment bill, then it will be good. Yes, in a moment, I would like to ask the Undersecretary to answer this question. Why is it that no sex workers have dared to complain against police officers? The previous Secretary for Security said that there was no breaking of the law, but in fact it was all because no one dared to complain. Why don't you give us sufficient time to have a discussion? Well, quite a lot of members are going to speak. Mr. Kwok Wai Keung and then Mr. Poon Siu Ping. Thank you, Madam Chair. I would like to thank the deputations for coming because they have reflected to us the views of the employees. Before the amendment, only the customers will be protected and not the service providers. Now, it is hoped that it will be extended to the employees as well. So I hope it will be done ASAP. Just now, many employers' representatives were saying that they were afraid that they couldn't discharge the duty. They hope that the administration would take up the duty. Well, there are employers who are not doing their job. Now, for frontline staff members at the workplace, well, in case they are subject to sexual harassment, I think the employer should come forward and at the very first instance stop the case from getting worse. And the employer should also warn the relevant customer, saying that he should stop it or he should be driven out. Now, the employer is in a position to say so, but not the employee. So in terms of protecting the employees, we all expect the employer to take up the responsibility. Well, in fact, we understand from the submission of the Chinese General Chamber of Commerce that their members are worried. Well, it is said that we should clarify as to what can be done by employers to prevent such offences. I think it is necessary to have a set of guidelines as suggested by the the Chinese General Chamber of Commerce Administration. For Mr. Kwok's point, indeed, the employer's liability is not covered by the bill. Just now, many speakers have also raised this point. Well, we have just heard that there are different views from the deputations. The same is true at the community's level as to whether we should include this point as well. Well, in fact, the EOC has just completed a public consultation exercise. This point was also included. We want to have an overall view, and then we will ask them to collate the views for us so that we can have an overall consideration. Next, Poon Siu Ping and then Gary Fan. Thank you, Madam Chair. I'm grateful to have the deputations' views. Most of them have said that they would like to see the early enactment of the bill. Just now, many deputations have talked about the complaint mechanism and the role of the government. I want to take this opportunity to talk about the complaint mechanism. Of course, we know that the EOC receives the complaints. 512 cases of complaints have been received concerning sexual harassment from 2009 to 2014. Mr. Lee or even Mr. Yang have been saying that they are critical of the complaint mechanism. what is the government's response? And will the government consider further improving the complaint mechanism? Thank you. Admin? You want the admin to give a reply? No, I want to direct the question to Mr. Lee of the Liberal Party, for example. Yes, Mr. Lee. Well, a number of points here. The bill is still a bill, and therefore the law doesn't afford any protection to the service providers. After amending the law, then I think the EOC should enhance the publicity about the revision so that frontline employees are aware of the rights and they are protected. And then the EOC should establish a complaint mechanism so the frontline employees can have justice done by lodging a complaint instantly. What about the administration's reply? Yes, admin. Just now, a member or two did mention this point. So did the deputations, namely the complaint mechanism. Just now, Mrs. Ho referred to 500 plus cases. She wondered why so few were given legal assistance. Well, these are very specific questions. In the second session of today's meeting, we can benefit from the input of the EOC, and then we can get more details from them. And we can also talk about the guidelines, because after all, the EOC is the enforcement agency. Gary Fan and Danny Chet Yan. Thank you, Madam Chair. We are grateful to have the deputations with us. I welcome what the EOC has said in the letter. That is, they would take up our proposal to use a neutral term. I think the government should do it now instead of waiting for the revision exercise to be completed. That is, now the administration's explanation is that most of the victims of sexual harassment cases are females, and she would also cover he in the bill, but then it is ironical and is not in step with the international practices. Usually, at the international level, they would rather use neutral terms, that person, a person, etc. So even for indecent assault, we will also say that if a person is assaulted, then the person assaulting that person is committing offense. So I just wonder if the administration can give a reply immediately. It's better for the administration to move an amendment and move it now. In a moment, the DOJ can answer this question. I think at the last meeting and at today's meeting, the same points have been raised. I think you would understand that we cover two-way, we cover all sorts of relationships. Men against women, women against men, men against men, and woman against woman. And we are dealing with just one of the components. But then the same construction, the same drafting applies to many aspects of the anti-discrimination laws. If we just address this point here, then there will be inconsistency across the different legislation. Well, you may want to say that perhaps we should do it across the board, but then it means that we have to read it across the legislation, and in fact, we can see that for this particular aspect, we would like to do it ASAP so as to benefit hundreds of thousands of employees. So as far as timing is concerned, we want to bring this into effect ASAP so that in case they fall victim to sexual harassment, they will be protected. For other aspects, well, in fact, the UC has already received tens of thousands of submissions. I'm sure the UC will collate the views and will come back to us. For the point made by Mr. Gary Fan, I think probably the society would also come back with different views, and then maybe at that time we take up this matter, it will be better. I think the crux of the matter is we want to enact the bill ASAP. Now, we have many deputations, and we have said that we would end this session at about 11:15, so I don't think we should keep them here for too long. But of course, you know that in the second session, we will get the representatives from the EOC. So I'll give the floor to Richard Yan, and then we'll draw in line. Helena Wong, Raymond Chen, Sid Ho would also speak again, 2 minutes each, and I will draw a line there. Richard Yan. Well, we believe that employees should be free from sexual harassment. There's a loophole here, that is harassment by the customers. Yes, we welcome the bill as a progress, but then it is a very late one. Just now, we have heard the views of the deputations. I just wonder whether the employer should be made to take up more responsibility. It isn't just a matter of the employer having to bear the criminal liability, but then the employer is in control of the workplace where the service is provided. So I think the employer is duty bound to make sure that the workplace is free from sexual harassment. We have heard from the speaker concerning the catering industry. Well, if someone is perverted, then whether the target is good looking or not will not make any difference, though the catering industry is threatening that perhaps they will stop employing good looking staff members. Now, I don't think the employer is criminally liable because the employer is not assaulting the workers in a criminal sense. But then the employer should do more, and we expect them to do more to provide a workplace which is free from sexual harassment. Well, also in the case of teachers in classrooms, again, teachers should make sure that the classroom is free from bullying. Same like employers making sure that the workplace is free from harassment. So I want to seek the views of the employers. It may not be criminal liability, but maybe they should also bear some responsibility in promoting the idea. Who would like to answer this question? Yes. Ms. Wong. Talking about the liability of the employers. Yes, employers are supposed to provide a safe workplace. Now, for the SDO, there is also this vicarious liability. If the employer doesn't have an effective mechanism to stop this, then the employer will be made liable. So if the employer has already discharged his duties, and if out of his control, a co-worker sexually harasses another worker, then the employer won't be made liable. I'm sure the OC can clarify this point later on. I think the matter is the employer has the duty to maintain a good and safe working environment instead of being made free from all sorts of liabilities. Mr. Xu? Yes, I'll give you 2 minutes. Yes, I would like to go back to the point made by Mr. Lee Cheuk-yen. That is the role of the employer. Imagine that you run a very small shop, a few hundred or 1,000 square foot, and then the employer can see everything. We all have a sense of justice. When something happens, then we'll of course act on it. But then if the shop is a large one, having a few stories, then it will be difficult to be sure.
So you can come up with codes of practice, and if you can tell the employees if you are sexually harassed, then you should also report the case to the police. But then what if this is just a beer promoter, and if she's sexually harassed, then will the employer also have to appear in court to defend himself? I think we'll be lagging behind that of Singapore and so on. And how are we supposed to do our business then? All right. 3 members would like to ask in the second round, but then as we can discuss this a bit later, so I can only give you a shorter time slot, only 2 minutes. Helena Wong. Madam Chair, I'd like to ask the DFJ to answer this question. Is it that in discharging their duties, the policemen in no circumstance would be allowed to sexually harass any person at the scene? Because as far as I am aware, for example, on interception, in conducting stop and search, there are guidelines saying that only police officers of the same gender can conduct the stop and search. But what if a male policeman trying to bear hug a female protester from the back, and indeed some policemen did commit such acts? So can you confirm if the female protester feels being harassed, being offended by a policeman trying to bear hug her from the back, then would that be treated as sexual harassment? Well, thank you. As I've already pointed out that under the SDO, it binds the government as well. That's why the employee of the government cannot commit offences under the SDO. In other words, the SDO covers government employees, including all staff of different departments, in providing goods and services. If they commit any acts of sexual harassment, they would be caught by the SDO. As to whether or not bear hugging another person would be treated as a form of sexual harassment, that would depend on whether or not that would be defined as sexual harassment under the law. I think his answer is ambivalent. All right, if the person who was bear hugged felt offended and harassed, that would already be the subjective sentiment of the victim, and therefore it should be caught. All right, if you are out of consciousness, and if I have to take you out of the room, and if I have to carry you, then will I be treated as sexually harassing you? Well, please do not try and answer on their behalf. I put a question to them. Well, he has already answered your question, according to the chair. Mr. Raymond Chan, well, does that include employer and also the supervising officer's responsibility? Because many deputations are concerned about this. Indeed, I am not in favor of expanding that indefinitely. For example, if a ward officer is sabotaged by someone else, and then if we have to be held liable for that, then that would not be fair. But then if the employer just sit back and do nothing about it, for example, if the employee informs you of sexual harassment, and if you just take no action and then allow that to continue to happen, then in those circumstances, should you share the responsibility? Because in the paper, we also asked this, and the administration's reply was, all right, if it's confirmed that the employer has not taken reasonable and practicable action in preventing other employees from being sexually harassed by customers, then should the employer be held liable for that? And the answer is that the EOC is now conducting a public consultation, including whether or not the employer should be held legally liable for employees who were sexually abused at the workplace. And after the EOC has received the submissions, they will be making recommendations, and we will consider that. So in other words, if the amendment provisions are approved intact, then the liability would not be extended to the employer. Can you make it clear to the deputations? Undersecretary, if we were to expand that further, as I repeatedly said, we'd like to listen to the recommendation by the EOC, and then there needs to be further discussion in the community, and there needs to be an agreement between the employer and employee before this is legislated. Okay, we'll discuss that with the EOC. We understand your concern. Next, Sit-Ho. Just now, 2 representatives from the Jockey Club told us that in the course of providing services, because of a shortage of manpower, people just call them up and abuse them on the phone. So I don't think that's targeting the individuals who were taking or picking up the phone. They just hold abusers when anybody picks up the phone. So I'd like to know, in certain circumstances, it's not just about the Jockey Club. Alright, people might be harassing 1 or 2 or even a particular person, so that they would just call the service provider, and then they would hurl abuses against the person picking up the phone calls if they have got specific targets in mind. And if the employer does not take action in protecting that employee, then should they be held liable as well? Which party would you like to put your questions to? The administration. Alright, DFJ or Undersecretary Mr. Lau Kong-wah? Yes, Madam Chair. As I've said, on employers' liability, well, in this bill, that's true. It's true that we have not included them, and if you think there is a need, then we will have to go through a process. But then, as to the situation referred to by Ms. Ho, precisely in the amendment bill, if it's enacted, is important, because at present, if there are employees in different workplaces, including the Jockey Club, today they are not protected, then that kind of a harassment can happen day in, day out. That's why we hope that the legislation can be enacted as soon as possible in order to protect these employees. Of course, we will try to do that as soon as possible, but then we believe that the scope should be expanded. That's why I was putting this to the Undersecretary. So, Undersecretary, please do not try to shy away from this. Next, Elizabeth Quart, I can only give you 2 minutes, even though you're asking in the first round. Thank you, Madam Chair. I've heard many deputations, and I'd like to thank them for coming today. I also think that we should enact the amendment bill as soon as possible so that employees can be better protected. I understand that employers are also concerned, and that employees might feel that the scope is not broad enough. But then I suggest that we should pass this as soon as possible, and then we can discuss if there needs to be further enhancement or improvement. With regard to the employers' concerns, I'd like to put this to the administration. If we have to wait till after the consultation conducted by the EOC, and then there would be another round of discussion in the community, well, in the interim, can you give some guidelines to the employers and employees so that their concerns can be allayed? Administration. Well, Madam Chair, I think we will also have to put this to the EOC, but then in principle, well, between the employers and employees, of course, they'd like to have a good environment so that they can do their jobs properly. As to whether or not whether there should be guidelines and how the guidelines should be drafted, I think we'll have to put it to the EOC. Yes, any further follow-up? Well, that being the case, okay. I think we have to wrap up our first session this morning. I'd like to thank the deputations for coming. With regard to what you just said, your questions and suggestions, I hope that the administration can give us a written reply as far as practicable. Okay, thank you very much for coming. You may now leave. and then we will have a 3-minute break, and then we'll come back again for the second session.